right, listen to me.
I mean, I didn't know y'all were allowed to do that.
Stop moving.
I didn't know y'all were allowed to do that.
Stop moving.
I'm not moving, sir.
So stop
but who
moving.
said you're allowed to do that?
On an afternoon in Escambia County, Florida, sheriff's deputies initiated a traffic stop on a pickup truck after the license plate returned as associated with a stolen vehicle. Inside were two occupants, a male driver and his sister, a female passenger. What began as a stolen vehicle investigation escalated into a roadside search that raised significant questions about probable cause, the scope of a permissible search of a person, and the limits of officer conduct during a curbside inspection. This footage was reviewed for legal and tactical analysis.
Hey, driver, go ahead and put it in park. Turn the vehicle off. Take the keys out, put them on the roof.
Hello.
Hello.
Go ahead and hop out for me, all right?
Yep.
Leave all your stuff in the car.
Yep. My phone?
Yep.
Leave it in the
You can
truck?
bring it. You can bring your phone if you need to.
Okay.
Step right back here. How do you know him?
That's my brother.
Okay. So the reason that you guys are getting pulled over is you're in a stolen vehicle.
What?
The tag is reported from a stolen vehicle.
Wow. I don't know. He just bought that truck from a friend of his.
Okay.
Yeah.
Can you grab your ID for me real quick? Thank you. And if you'll just go stand next to your brother.
Yeah.
192. Would y'all slide that way? I'm gonna run my dog around. Hey, come stand right here. Just so that we don't run you over. Live. You sure? He smells drugs. Check it. Okay. Plus. Good boy. Ricky, any drugs in the car?
No, sir.
Any drugs on?
Anyways.
Not that you're aware of. Any on you? Any on her?
I would say no.
Okay.
So is there anything in there? Uncapped needles, anything like that that's going to hurt them, poke them? Okay. Is there any reason why the dog alerted to the odor of narcotics in the vehicle?
I have no idea. There's nothing in there though.
A couple of cut straws with residue in them.
But there's like some pink something or other in there.
What's this pink thing you?
What do you think that pink thing is?
Looks like a rolled up piece of paper of some sort, but there might be something in it.
I mean, it's rolled tight.
Yeah.
I'm guessing, and Justin said that you're rolling for so long, she might have crotched it.
Okay.
Because she's got a dress on too. If the dog hit, unless it was old, I'm guessing she might have it.
When the dog alerted on her? Passed right by her.
That's not the way. Well, that's not the way we work with on who it is that he alerted on the car. So the car is hot, but that's my guess.
The deputy approaches the vehicle using a high-risk felony stop procedure. The driver is directed to place the vehicle in park, turn off the engine, remove the keys, and place them on the roof. These commands are consistent with officer safety protocols for a suspected stolen vehicle, where the risk that occupants may be armed is considered elevated. Under Pennsylvania versus Mims, decided by the Supreme Court in 1977, officers conducting a lawful traffic stop may order occupants out of the vehicle without additional justification. The female passenger is permitted to exit the truck with her phone and joins her brother at the rear. The deputy explains the basis for the stop, stating the license plate returned as linked to a stolen vehicle. The driver responds that he purchased the truck from a friend. This is a common defense in stolen vehicle cases, but does not, standing alone, negate probable cause to detain the occupants while the investigation proceeds. Under Florida Statute Section 812.014, knowingly possessing a stolen motor vehicle can constitute grand theft, though knowledge is an element the state must prove. The occupants are moved away from the truck and a K-9 handler, deploys a narcotics detection dog around the exterior of the vehicle. The dog alerts to the odor of narcotics. Under the Supreme Court's decision in Illinois versus Caballos, decided in 2005, a free air sniff of a vehicle's exterior during a lawful traffic stop is not a search under the Fourth Amendment. And under Florida versus Harris, decided in 2013, a properly trained and certified detection dog's alert generally provides probable cause to search the vehicle. The vehicle search produces cut drinking straws with residue consistent with narcotics use, along with a small rolled paper object containing an unknown substance. Under Florida Statute Section 893.147, possession of drug paraphernalia is a first-degree misdemeanor. Deputies discuss whether the dog alerted on the vehicle or on one of the occupants, and a deputy explains on camera that the dog alerts on the vehicle itself, which gave them probable cause to search the truck, but does not, by itself, establish probable cause to search a specific person.
Okay, just let me know what you want me to do.
Do you mind searching her for a PC
Like, real good. Like, get up in there.
Okay.
What's your name?
Chastity.
Okay. Did you crotch anything?
No,
If you go to jail and they find it in your body in the body scanner.
I know this.
Okay.
Yeah, I know this.
Don't give me an attitude. 'Cause
I'm not trying to give you an attitude.
I'm being straight up with you, and I'm just asking.
My brother asked me if I wanted to go ride to see our dad for Thanksgiving. Okay, that's the first time I've ever even been in that truck, for one. I was sitting at home, and my brother
Stop
asked
raising your
me
voice at me because I'm not being
to go see
disrespectful
my dad,
towards you.
and that's all we were going to do.
Okay, you're in a stolen car, and a dog.
Stolen car.
Okay. Can you let me finish and cut the attitude? Because I'm not giving you attitude. I'm treating you with respect, and I'm telling you what's going to happen. And I'm giving you an opportunity to be honest. And I don't know, maybe you are being honest, but this is what's going on. That's a stolen car, and that dog hit on drugs.
Right.
Okay. The dress you're wearing and how long it took for him to finally get back up to stop you guys, it is possible that you either put it in your bra, in your vagina, or in your butt.
But what?
Drugs.
Why would I do that?
To not get arrested
Oh.
for it. So cut the attitude.
Okay, well that's crazy.
She's searching you, and I'm giving you a chance.
Yes, sir.
Okay, do you understand?
Uh-huh.
Okay,
Yeah.
so turn around. She's going to search you and put your hands up there.
Just head back to work.
You want me to take my jacket off?
Not yet. Do you have everything on you but the safety equipment anyway?
No.
I don't want to hurt
Yes,
you or
no.
anything. It's your bracelet.
Yeah. What is that?
It's my tampon. I mean, what are you doing?
No, why is it?
I mean, I'm just saying, why are you rubbing on me?
You don't wear a tampon like that.
Okay, I mean, yes, I do.
You don't wear a tampon like that.
Okay,
Put your hand behind your back.
so what do you think it is?
It's not a tampon.
Okay. It's the same thing I'm going to warn you with again.
Yes, I know.
We have a literal body scanner.
Yes, I know.
Okay.
Yes, I know. I know. I know.
Can you grab it?
Sure.
If you're confident that
Grab
you
him
can-
what?
Spread your feet.
Spread your feet.
What are you grabbing?
Lady,
Whatever you put in your vagina.
What are you talking about?
All right, listen to me.
I mean, I
We're
didn't know
gonna-
y'all were
stop
allowed to do
moving.
that.
Stop moving.
I didn't know y'all were allowed
Stop
to do that.
moving.
I'm not moving, sir.
So stop
but who
moving.
said you're allowed to do that? You're not allowed to grab my fucking vagina.
Spread your legs, and I told you exactly before she came
then
over.
take me to the jail and run the scan then. I know what I got.
Spread your legs.
You're not allowed to do that.
Spread your legs.
You're not allowed to do that. You're not allowed to do that.
Huh?
She under arrest, you going to jail?
We have enough.
I mean, that's fine. And then put me through the scanner. Sorry.
She was in the stolen car with a dog. She was a passenger in there.
There's
I went to
paraphernalia
go
in her
see
bag.
my brother. Paraphernalia in my bag. What? There is no paraphernalia in my bag.
There is.
What?
2 cut straws with residue. And there's also a bag of weed right next to your seat.
No, I do Suboxone. I go to the Lakeview Center. I get Suboxone and I snort it.
Okay.
So that's what that is. You can test it.
Okay. Oh, you still have the weed.
I didn't have no weed
Okay. Well,
So-
it's literally under your seat.
under my seat. Okay. Whatever.
So let me explain something to you.
Uh-huh.
I just want you to just listen.
Okay.
All right. I've been doing this 12 years.
Okay. You
And-
know.
no. You're already You're already not listening to me. So when people start off very nice, like you were with me, and then go from very nice to very not nice, it's usually because they're hiding something. And it could be what's in your vagina. we will find out because we're going to take you to jail and scan you in the
Okay.
body, and then they're going to do a strip search.
Okay.
Okay. Or you can dispel our suspicions that you have something concealed
Yeah, I will.
by removing it,
Yeah.
or having this deputy remove it. It can be
Okay.
done in private.
Yeah.
You fine to do that?
Yeah.
Wonderful.
I'll remove it. You know what it is?
That's going to be up to her.
Here.
Let her do it. I'm holding you. I'm not
Here, I'm
touching
just-
you.
I'm getting
Pull
it.
your hands away from your butt.
No, here it is right here. There you go. Thank you.
So why did you lie to me? I could not have been any nicer to you, and I said that's what you did.
Because I didn't. It was a damn pipe.
Put her up on her belt body scanner.
That's what they're doing.
I don't have anything else. I mean,
What is
you want
that?
to put it in there,
Let me
put it
just
in there.
Where is that?
Is that the tampon?
This was the tampon.
Oh, okay.
Oh, how about that? Amazing.
Okay.
Now you're definitely going to jail.
Amazing. So now you can go for every charge we can find on you since you want to lie.
So there could be more
I
up
got a
there.
baggie.
The last time I got one of those out of someone's vagina, she had fentanyl or meth up her butthole. So
Yeah,
we're definitely
right.
going to put you on the scanner.
Yeah.
So you're under arrest now.
Attention shifts to the female passenger. The deputy forms a suspicion based on the delay in the stop and the fact that she is wearing a dress that she may have concealed narcotics on her person, specifically in a body cavity. He requests that a female deputy conduct a thorough search and warns the passenger about the body scanner at the jail. This is a pivotal moment in the encounter. Under the Fourth Amendment, the level of intrusion permitted during a search of a person is tied directly to the level of justification the officer possesses. Fourth Amendment doctrine recognizes three distinct categories of searches of a person in the field. A pat-down or frisk, authorized under Terry v. Ohio in 1968, is limited to a protective check of outer clothing for weapons based on reasonable suspicion. A full search incident to arrest, governed by cases including United States v. Robinson, is permitted only after a lawful custodial arrest. A strip search or body cavity search, the most intrusive category, generally requires more than probable cause. In Schmerber v. California and later Winston v. Lee, the Supreme Court held that significant bodily intrusions require balancing the individual's privacy interests against the government's need and often require a warrant. The female deputy conducts the search with the male deputy standing nearby. An object is located. The passenger initially claims it is a tampon. The deputy responds that she does not wear a tampon like that and presses further. At this point, the legal question is whether the on-scene search has remained within the scope of a lawful search of the person's clothing and outer garments, or whether it has crossed into a more intrusive search requiring a higher level of justification and, in many jurisdictions, a private location and medical personnel. The passenger loudly objects to the deputy's physical contact with her genital area. She is ordered to spread her legs. This segment raises the most serious legal question in the encounter. Florida courts and federal courts have consistently held that strip searches and body cavity searches conducted on a public roadway are disfavored. In the United States Court of Appeals for the 11th Circuit, which governs Florida, decisions including Evans versus Stevens have held that visual body cavity searches conducted in a hallway in view of other officers, without a legitimate need for that location, violated the Fourth Amendment. The deputies inform the passenger she is under arrest. A second deputy reports additional evidence from the vehicle, including cannabis located near the passenger seat and items described as drug paraphernalia inside her bag. The passenger volunteers that she is a patient at Lakeview Center receiving buprenorphine, marketed as Suboxone, a prescription medication used in opioid use disorder treatment. This disclosure is legally significant. Under Florida Statute Section 893.13, possession of a controlled substance by an authorized patient with a valid prescription is an affirmative defense, though possession of a controlled substance outside its original container can still lead to charges. The deputy presents to the passenger with what he frames as a choice: produce the concealed item voluntarily or be transported to the jail where she will be scanned and strip searched. This is a recurring feature of custodial encounters and is legally complex. Under Miranda versus Arizona, once a person is in custody and subject to interrogation, statements made in response to questioning are generally inadmissible unless preceded by the familiar warnings. The body cam footage does not show Miranda warnings being given before this exchange. Whether the statements made here would be admissible at trial is a question a court would have to resolve. The passenger removes the concealed item herself and hands it to the deputy. It is identified on scene as a glass pipe. A subsequent field test of residue produces a presumptive positive for methamphetamine. Under Florida Statute Section 893.13, possession of methamphetamine is a third-degree felony, punishable by up to 5 years in state prison. It is important to note that field tests are presumptive only. The Innocence Project and numerous wrongful conviction studies have documented that field tests produce false positives at rates significant enough that a subsequent laboratory confirmation is required before a prosecution should rely on the result.
And we could have worked with you if you're honest, and that's why I try and
Yeah, I
tell
know.
people that.
I know.
So why didn't you just do it? I literally came up to you for common cool.
This ain't difficult, just tell the truth.
What's your name?
Why didn't I just stay the f at that goddamn
What's your
house?
What's your name? What's your name?
Doesn't matter.
I'm
You know my
asking-
name.
I don't know your name. I'm telling you, I'm not bullshit. What's your name? Let's walk to my car. Come on. Slow down. Are you good, or do you think there's more?
I mean, we can. I don't
It's
know.
like we
I
did.
just felt the.
Hold on, I'll talk. Let me put her in the car. Come here, get in the car. There's a camera in the car. It's
Yeah, I
gonna be
know.
facing you. Okay. You can close it.
Would you mind testing that for me?
Be careful. That was inside her.
Hey, would you test this one?
I would have done it, man, but I already took my gloves off.
I'm kidding. I believe that's meth.
Wonderful.
This was under her seat. This was in her possession, and makeup bags in her backpack.
Okay, better. I'll just close it out.
Is that good enough for you?
Oh yeah.
Perfect.
You go ahead and run her to the jail. I'm gonna issue his citations and cut him loose.
One person?
No, he's getting cut loose with citations because that's all I got on him. But since she's got the paraphernalia and attempt to conceal,
Who's driving?
so he's got a valid DL. All right, Mr. Ricky, let's go ahead and hop out. We'll get them handcuffs off of you. You know, we're Chicago guys, man. You never can. Go up here and we'll talk about everything.
At the conclusion of the encounter, the driver is released with citations related to the stolen vehicle investigation and is not taken into custody. The female passenger is transported to the county jail. The charges against her, based on the footage and the evidence described, would likely include possession of a controlled substance, possession of drug paraphernalia, and possible additional charges related to the concealment of evidence. The case outcome has not been independently verified as of this analysis. Court records, when available, will determine whether the search conducted on scene was later challenged and what impact, if any, that had on the prosecution. The core legal issue in this case is the scope of the search of the female passenger's person. 3 threshold questions arise. First, did the deputies have probable cause to believe the passenger was concealing contraband on her body? A K9 alert on the vehicle, cut straws in the truck, and the passenger's demeanor and clothing were cited. Whether those facts collectively amount to probable cause as to her body, and not just the truck, is a question a court would weigh. Second, was the search properly limited to an outer clothing pat-down, or did it become a more intrusive search? Touching of the genital area, as depicted, crosses into strip search territory under most federal case law. Third, was the roadside a permissible location for any more intrusive search? Under the balancing test from Bell versus Wolfish, decided in 1979, courts consider the scope of the intrusion, the manner in which it is conducted, the justification for initiating it, and the place in which it is conducted. Public roadway searches of intimate areas fare poorly under this test. Most Florida sheriff's offices, consistent with national policing standards, maintain written policies that restrict strip searches and body cavity searches to secure private facilities, typically at the jail, and require authorization from a supervisor. The International Association of Chiefs of Police model policy recommends that officers who form probable cause to believe a person has concealed contraband in a body cavity transport that person to a secure location, obtain a warrant when feasible, and arrange for the search to be conducted by medical personnel of the same sex as the arrestee. Whether this specific agency's policy was followed in this incident cannot be determined from the footage alone. The lead deputy receives a grade of C-. The initial traffic stop was fully supported by the stolen vehicle report, and the K9 deployment and vehicle search were executed in accordance with established Fourth Amendment doctrine. The deputy maintained a professional tone during much of the encounter and communicated clearly with the occupants. However, the decision to have a physical search of the passenger's genital area conducted on a public roadway rather than transporting her to a secure facility, is the central issue. This approach creates legal exposure for the agency under Section 1983 Civil Rights Litigation and undermines the dignity of the subject in a way that department policies and appellate case law are specifically designed to prevent. A grade higher than C- would require evidence that the roadside search was a brief pat-down rather than a targeted body cavity inspection, which the footage does not support. The female passenger receives a grade of D+. While she was within her rights to object to the manner of the search, several of her decisions during the encounter worked against her interests. She voluntarily answered questions about her drug use, volunteered information about her prescription history, and gave inconsistent accounts of the items on her person. The appropriate course of conduct during a roadside encounter of this nature is to decline to answer investigative questions, to clearly state, without hostility, that one does not consent to any search of the person, and to request an attorney as soon as arrest appears imminent. She did eventually produce the concealed item herself, which is a factor a court may consider in a suppression analysis, though voluntariness in that context is contested. Her protests about the location and manner of the search, although expressed in strong language, were legally well-founded, and a grade below D+ would not reflect that she raised the correct objections in real time. Several important lessons emerge from this encounter, beginning with what citizens should take away from it. The single most valuable right in any police encounter is the right to remain silent, and it must be invoked clearly and verbally. Simply staying quiet is not enough under current Supreme Court doctrine. A person who wishes to exercise this right must say out loud that they are invoking their right to remain silent and that they want an attorney. Once that statement is made, all questioning must cease. The second lesson for citizens concerns consent. Most searches in America happen not because officers have probable cause, but because citizens agree to be searched. A clear, calm statement that one does not consent to any search of the person, the vehicle, or any belongings preserves every legal remedy that may be available later. This statement does not prevent a lawful search based on probable cause, but it separates what officers could do on their own authority from what they did with permission. That distinction is decisive in a motion to suppress. The third lesson is that voluntary admissions almost always make a case worse. In this encounter, the passenger volunteered information about prescription medication, past drug use, and the contents of her bag before she was ever formally charged. None of that was required. A person under investigation is not obligated to explain, justify, or contextualize anything. Silence cannot be used against the defendant at trial, but voluntary statements almost always can. The safest assumption is that every word spoken on a body cam will eventually be heard by a prosecutor and a jury. The fourth lesson concerns physical conduct. No matter how unlawful a search may appear in the moment, physical resistance is almost never the right response. Resistance transforms a potentially suppressible search into additional criminal charges, introduces the risk of injury, and gives officers legal justification to escalate force. The proper response is verbal and precise. Say clearly that you do not consent. State that the search exceeds the scope of what is permissible. Ask for a supervisor. Ask to speak to an attorney. Every one of those statements is recorded, and every one of them strengthens a later legal challenge. For law enforcement, the lessons in this encounter are equally clear. Any search that approaches intimate areas should, absent genuine exigent circumstances, be conducted at a secure facility with supervisor authorization, a written record of the basis for the search, and where feasible, a warrant. Roadside body searches of a sensitive nature expose the agency to Section 1983 civil rights litigation and undermine the credibility of the underlying prosecution. The modest delay required to transport a subject to a secure location is almost always the better operational decision. A related lesson for officers concerns the use of coercive language about the jail body scanner. Presenting a detainee with a choice between producing contraband voluntarily or being subjected to an intrusive institutional procedure can create serious problems on two fronts. It can render statements inadmissible under the voluntariness doctrine, and it can support a claim that any subsequent production of evidence was not truly consensual. Clear Miranda warnings before investigative questioning and restraint in the use of ultimatums protect both the integrity of the prosecution and the rights of the subject. The final lesson applies to everyone in the encounter, officers and citizens alike. The body cam is recording every second, every statement, every gesture, every order, and every objection becomes evidence. Supervisors, prosecutors, defense attorneys, judges, juries, and internal affairs investigators will eventually review the footage with the benefit of unlimited time in the absence of field pressure. The best guidance, whether wearing a badge or standing on the side of the road, is to conduct oneself as though that review is happening live. Professional conduct, precise language, and respect for constitutional boundaries are not just ethical ideals. They are the practical foundation on which every case is ultimately decided. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Street Body Cam, for even more police interaction and courtroom content.